want to know what it's fighting for. Podcast for George. 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 Oh, yeah.
Hello. Hi. How are you? Welcome back in to another podcast by George. Well, in the news business, this is kind of the summer doldrums kind of time of the year when, I don't know, it used to be in broadcasting anyway, news would get a little bit slow. And I kind of had a little slow period here, maybe a week or two ago, but not anymore. It seems like the podcasts are coming fast and furious, and it's all, news that I would rather not have, it seems like. And that's what we're going to be talking today with our old friend about. Randy Evans is back on Podcast by George. And if you haven't seen him on the show before, Randy is executive director of the Iowa Freedom of Information Council, a nonprofit education and advocacy organization that works on issues pertaining to open government and government accountability. Randy took over that role in 2015 after a 40-year career with the Des Moines Register. This guy has the bona fides, folks. He knows where it is that he speaks. I don't know what the hippies used to say back in the day. Randy, thanks for coming back on a Podcast by George.
George, I appreciate it. Appreciate the invitation.
Well, I've told people before that I could have named this podcast, I think, What in the Hell? Because I come across these news stories all the time, and it's like, that's what comes to mind, and this is the one that I saw, and you're a part of it. So I want to bring this up on screen. I'm going to read this. We'll get your reaction and get a little deeper into it. So here we go. Okay, this is from Ryan Foley with the Associated Press. It's been doing some great work of late, by the way. The headline reads, Iowa argues open records law is not well-recognized policy. Dateline, Iowa City. Iowa's open records law is not a well-recognized public policy and thus does not give job protections to employees who fulfill public information requests, the state attorney general's office contends. State lawyers representing Governor Kim Reynolds and her spokesman, Pat Garrett, make that assertion in asking a judge to dismiss a wrongful termination lawsuit filed by Polly Carver Kim, an old broadcaster, the Iowa Department of Public Health's former longtime communications director, was her job with the state. Now, Carver Kim argues that Reynolds and Garrett pressured her bosses to strip her duties after the coronavirus pandemic began last year and ultimately forced her to resign because of her willingness to release records and data sought by journalists and the public. She alleges that the Public Health Department, at the behest of the governor's office, sought to slow, stifle, and otherwise divert the free flow of information about Iowa's pandemic response. And if you follow this podcast, you know I'm all about the free flow of information, not only in the pandemic response, but in everything. Now, her lawsuit alleges that Garrett instructed her to hold one request, even though the information was ready, and that she was chastised for giving the New Yorker magazine records that had already been released to others, and for updating the department's website with COVID-19 data before a Reynolds news conference. The final straw, it claims, was her release of media-requested data showing abortions in Iowa had spiked by 25% in 2019, and she was summarily dismissed after making that information available. Carver Kim contends that her ouster a year ago was a wrongful discharge in violation of public policy. She argues she was simply complying with a 54-year-old Iowa Open Records Act, which states that the disclosure of public records is generally in the public interest, even though such examination may cause inconvenience or embarrassment to public officials. And I mean, just get the irony there. The governor's chief of staff, Sarah Craig, said in a statement Friday, the lawsuit is without merit. Okay, that Open Records Act is 54 years old, and Randy, you were almost on the job by then. I saw your comment on this. Let me put this down. Get this off the screen. Like I said, I was madder than hell when I read this. I think you kind of blew the side of your head out. I read a quote where you said this is the worst thing, the worst circumstances of late here, what we've been seeing coming out of this governor's office and around the state in 50 years.
Well, the open records law was written by the legislature, signed by the governor back then. It has been amended multiple times and signed by the governor. And the fundamental concept there is that the public, the people for whom government exists, the public is entitled to know what their government is doing so that they can evaluate, the office holders can evaluate the job that government is doing. And if you shut off the spigot of information, whether that is a spigot that is pouring out public records or whether it is a spigot that is providing access to public meetings or press conferences, you're cutting the legs out from under the sunshine laws that democracy needs to function in the best interests of the citizens. Whether you agree with Polly Carver Kim's being pushed out or not, the fundamental issue in this lawsuit ought to trouble everybody, whether you're a Republican, a Democrat, an independent, or a Whig. It should concern you because if government employees can be fired for complying with the public records law, then the citizens of Iowa are going to be the ones who suffer, and the so-called public records law is going to cease to exist as we know it.
Well, clarify this a little bit because I'm a little confused on this. She's working for the state of Iowa. The state is saying they can fire her because she's an employee at will, and we know what that means. Anybody that's been one, and I have, they basically can fire you when you show up for work because they don't like the color of your hair or the fact that you don't have any hair. They can get rid of you for any reason if you're an employee at will. But she's contending that this is a wrongful termination. It has to be very specific, and it has to do with the release of these records. Now, is she an employee at will that can be let go for any reason?
Well, I don't think there's a question. I don't think there's a dispute about whether she was an at-will employee. She was not a member of some bargaining unit,
right,
which provides some job protection. But the issue isn't whether she is an at-will employee or not, because if she were being pushed out of state government because she was doing something improper, because she was breaking a law, whatever that legitimate reason was, that would be fine. But my contention is that complying with the public records law should not be the basis for terminating somebody's employment any more than we ought to be able to terminate an employee who in state government who is not arriving on time for a meeting because there was traffic on the highway and he or she chose not to exceed the speed limit to get there on time. It's the reasoning that is being cited in this case is what is the troubling part, because if government employees are afraid of embarrassing the boss, if they're afraid that some record, that whether it's a journalist is seeking it or whether it is a Joe ordinary civilian is seeking it, if the release of a record in compliance with the public records law is creating a fireable offense, if the boss is embarrassed, then the public records law is useless. We don't have a government administrator. We have, in effect, a dictator who is wanting to rule by edict rather than being guided by what the law requires. But it's, the fundamental issue here goes beyond just Polly Carver Kim. There was a lawsuit filed last week against the Iowa Department of Public Health, the agency that employed Polly. It was filed by a businessman from Utah who is trying to get public records pertaining to the the Test Iowa COVID
Yeah.
testing program that the state entered into a no-bid contract with several Utah businesses. The businessman in Utah was told that the records would be available in about 5 days to gather them up and review them and make them available to him. And that's been months later. I think all of this transpired in March, and here we are in August. One of the allegations in the Polly Carver Kim lawsuit is that the governor's communications director, after records had been cleared by an assistant attorney general for release, which means that they contain no confidential information that cannot be made public.
Right.
After these records had been cleared for release, the communications director for the governor directed Polly to hold on to those.
Mm-hmm.
The only reason that the public records law acknowledges that you can delay complying with a legitimate request is if you are needing to review the records to see if there is confidential information in them, or if you are going to court to seek an injunction to block their release. Neither one of those circumstances applied in the case of the Test Iowa records, but the governor's communications director didn't want these records being made public, presumably because they were embarrassing to the governor. They didn't fit with the governor's marketing plan or the strategy for communicating about Test Iowa. And none of those elements are recognized in the public records law. There's no asterisk that says, that a governor can ignore the law because it would be embarrassing.
Exactly. That's the irony of it, really. And it comes, her firing, Polly Carver Kim, came immediately after this abortion information was revealed. And of course, this is highly embarrassing to a governor, Republican governor of the state of Iowa, that's trying to push her rising star to the top of the Republican Party. So maybe that's coincidence. Maybe it's not. But that's the irony of it. I wanted to go back to the beginning of that article, Randy. Tom Miller talking about this well-defined public policy and all that. I mean, this is legal speak. This stuff is hard to understand. What's he saying?
Well, I mean, I am not a lawyer, and so I would hesitate to try to interpret what the Attorney General's staff is saying. But the public records law has been around for 50 plus years. If it isn't well established in 50 plus years, how is anything well established?
Yeah.
Because I think that, it is going to be, the Attorney General is hard pressed to explain to the people of Iowa why it is that the law is written in pretty plain language, and yet, the Attorney General's lawyers are in court trying to tap dance around that plain language in the statute, because the statute isn't written with may, that you may release these records. It's, public records speak to what shall be done, once a record is deemed to be public as opposed to confidential. All of this is just very troublesome. And as you can see from my hair, it's the sort of thing that'll put gray hair on your head.
Oh, I mean, I wish I had some to turn gray, maybe. I mean, it's just outrageous. I mean, it's insult to injury. Again, kind of a subtitle of this podcast. And maybe the insult on top of this injury is what you would call a sidebar, Randy, and it has to do with our good friend Laura Bellen with Bleeding Heartland. She's been trying to get into the governor's news conferences and get release of these records for months, years in some instances, and she's being stonewalled and being almost physically prevented from attending these news conferences of the governor. Now, Randy, reel me back in if I'm wrong on this, but my understanding, particularly when it comes to public officials, if these meetings are being held in a public place and she can be accommodated, if there's room for her and she's a journalist, which she most surely is. I mean, I can't believe that anybody could doubt that. She's got to be allowed into those news conferences. How are they keeping her out of there? Is that legal?
I don't believe it is. And it is exceedingly troubling that the top elected official in the state of Iowa, who is communicating to the people of Iowa through the means of a press briefing about an issue of considerable public interest in our state, and that was the assignment of 24 state troopers to supplement law enforcement officers along the southern border in Texas. The only justifiable basis for denying a legitimate reporter access to that briefing would be if there was a security concern about the reporter, in my view. And that is not the case with Laura. If this were a press conference that the governor in a campaign capacity was holding at a private venue off of the Capitol grounds, there may be a legal justification to allow the governor to pick and choose who is allowed to attend. But this was an official duty. It was in her official capacity as governor. I have never encountered this in 50 some years of working in the newspaper business and dealing with government officials. I mean, when I was a young pup of a reporter in Albia, Iowa, I would frequently call the press secretary for, at that time it was Governor Ray, where I would have questions about things that were in the news, and I would always get a call back. I would always get an answer. The questions I had would be answered. I would be invited to come to Des Moines if I wanted to ask Governor Ray these questions directly.
Yeah.
There was never any question whether I was a quote unquote legitimate reporter. I don't think there is any rational basis. And I think clearly the governor is treating some reporters differently than she's treating others. And I think this is occurring for reasons that are not recognized under the Constitution. This issue isn't one of Democrats or Republicans. This issue is one that ought to concern Iowans of all political views, because if they can't get questions answered by the governor, if they can't get access to information the governor has, then our democracy is being weakened every day.
It's a house of mirrors. I talk about these subtitles for my podcast. That could be one also. Well, I mean, you've got Republican politicians, most notably in this instance, Kim Reynolds. A lot of people say, she's got brass. She's a tough old gal, Well, what are you afraid of, Kim? I mean, are you afraid of Laura Bellen? Are you afraid of answering questions directly from real journalists? Come on. I mean, I thought you were tough. I guess the question for you, Randy, is executive director of the Iowa Freedom of Information Council. Is there recourse here? I mean, what would you advise? What kind of a call would you make? Is there a legal recourse for this? Is the answer in the legislature, or the legislator's going to have to do something? I wouldn't hold my breath on that one, I guess. How about other journalists? I mean, do they need to band together? I've always thought journalists were kind of weak on that. They're not very good at reporting and covering and uplifting journalism news. This is, journalism about journalists. You don't see a lot of that. I'd like to see this kind of stuff on the front pages.
Well, I think I'm confident that Laura is exploring the legal options that are available to her. I know the FOI Council, we're doing the same thing, both as it relates to the governor's decision to ban certain reporters from her press briefings, as well as what we believe is the blatant disregard for what her obligations are under the public records law. But the governor is playing the odds here, because to mount a successful lawsuit when you're going up against the attorney general's stable of lawyers, you need to realize that if you're going to get in it at all, you need to be in it all the way to the Iowa Supreme Court. And that kind of litigation could cost a journalist like Laura, an organization like the FOI Council, or anyone, upwards of $250,000.
Now, Andrea Sahuri, right? I mean, that's about what it cost her in the register, right?
So it's, government realizes that they're in the driver's seat in this regard, because they're using your money, my money, our tax money to hire lawyers and pursue issues in court, taking a chance that we're not going to be willing to mount the expense.
Well, like I said, it's not good news by any stretch. I'm going to give you the last word here. My last 2 cents on this. I've kind of sensed or felt that this has been coming for a long time. Daniel Ellsberg, and I know you're well aware of the Pentagon Papers. And, I mean, he got a by on a technicality almost by the skin of his teeth. I mean, Julian Assange is sitting over there in that prison in London. The United States wants to bring him back over here and try him for espionage, maybe hang him by his neck, for God's sake, and kill him. You've got this guy that was just in the news recently, Daniel Hale, that he was just convicted for releasing this information on drones killing civilians. Edward Snowden, of course, we're familiar with. Chelsea Manning. The list goes on and on. I mean, public information needs to be released. It needs to be out there if we're going to end wars, if we're going to answer questions. And I guess it's up to the people. It's going to be up to us, as just about everything is, just like Randy was saying. I mean, someday you're going to want information. You're going to want answers to questions that you have, and you're not going to be able to get it because the journalists have been denied access. They won't even be on the scene any longer if we don't take action when journalism and the First Amendment are under attack. Randy, give us a closer here.
Well, I hope that that your listeners will, take to heart that, whether they are interested in the particular topic that is being talked about at the governor's press conference, or if they're not particularly interested in access to the Test Iowa records that the businessman in Utah is wanting, there's going to come an issue someday that they're going to be interested in, and they're going to be frustrated when they can't get their questions answered. And that's when they're going to realize what is truly at stake. It's not that Polly Carver Kim was a saint, or that Laura Bellen is a saint. I mean, it is, the whole system of democracy in Iowa is built on trust. The people trust government to do the right thing. Journalists trust government to respond appropriately when they make a request for records. The trust structure starts to collapse around us when government officials think that they can just ignore questions that they don't like, requests that they would just as soon go away, or journalists that they would prefer to have doing something else rather than writing about the issues that are occurring in the state of Iowa. We all need to be concerned about this, regardless of whether we agree with Kim Reynolds or not, because the issues are just too important to let them slide.
Folks, that's Randy Evans. He's a member of the Fourth Estate. I mean, he's 4 decades on the job with the Des Moines Register. Laura Bellen, a member of the Fourth Estate. They're supposed to be separate, adversarial in some respects, and they are, and I'm glad they're on the case, and I'm glad that he's back on a podcast by George. Randy, thanks for coming back on.
Thanks, George.
Folks, that was Randy Evans. He's the executive director of the Iowa Freedom of Information Council, and I hope you appreciate seeing him on the show. And if you like Podcast by George, my closing comment, as always, is to go to YouTube, subscribe there, ring the notification bell, give us a thumbs up, leave a comment if you would. Same thing on iTunes. Like us and follow us on Facebook and all the places where podcasts are seen or heard. But that's going to do it for today. That's going to wrap it up. That's all there is, and there ain't no more. That's another podcast by George.